Dear friends, now we are going to episode number 5. Yesterday we had an introduction about the execution of decrees and orders. Today we will start the various provisions, dealing with the various provisions on the subject. Dear friends, I do not propose to deal with section 36 to 74 one by one and then order 21 rules 1 to 106 one after the other. I may go from here to there to here. I may deal with one section and then go to another section, not in the order. Likewise, depending on the circumstances in which it requires for you to study the subject. Now, please see section 36. As I said earlier, for all these classes you have to have your CPC on your side. It is not enough that you have it online or in your mobile or in your laptop. It is required that you have the book so that it will be easier for you to note down something there itself. Yes. Now take section 36. Section 36 provides that the provisions of the code relating to execution of decrees, so far as they are applicable, deemed to apply to execution of orders as well. Now, you know the difference between the decree and order. We have already dealt with. Decree means the formal expression of an adjudication, etc., etc., etc. And order is also defined in section 2. So execution, this part containing part 2 deals with execution. Part 2 in the CPC deals with execution. It contains section 36 to 74. 36 provides that this part will apply to execution of orders as well. Now take section 37. First 38. Code by which the decree may be executed. A decree may be executed either by the court which passed it or by the court to which it is sent for execution. This expression you remember. Court which passed it or to court to which it is sent for execution. What is the definition of the court which passed the decree is contained in section 37. You read section 37. Court which passed a decree, words to that effect shall mean decree is executed has been passed in the exercise of appellate jurisdiction, the court of the first instance. Where the court of the first instance has ceased to exist or to have jurisdiction, the court which the suit wherein the decree was passed was instituted at the time of making the application for execution of the decree would have jurisdiction. We are concerned mainly with clause A of section 37, that where a decree is passed by the appellate court, then the court which passed the decree is the trial court. Now I will give an example. You instituted a suit. You are the plaintiff. You lost in the trial court. That means your suit was dismissed. You file an appeal. In the appellate court, you succeed. That means a decree will be passed in your favor, decreeing the suit. There, the decree is passed by the appellate court. So, which is the court which passed the decree? Going by section 37, clause A. It is the court of the first instance. That is the trial court. So, that please bear in mind. So, the decree can be executed by the court which passed it, or to which it is sent for execution. Now, what is sending for execution? Court which passed it, there is no difficulty. You can go to section 37 and understand it. And what is sending for execution to another court? That requires consideration. Transfer of decree. You will get in section 39. 39. I will read section 39 to the extent it is relevant. The court which passed a decree may, on the application of the decree holder, send it for execution to another court of competent jurisdiction. So 39.1 deals with sending for execution of a decree to another court on the application of the party. 39.2 provides for exercising that power suo motu. Now we will deal with the application for sending the decree for execution to another court. In what cases, in what circumstances a decree should be sent or decree has to be sent. Clause A, if the person against whom the decree is passed actually and voluntarily resides or carries on business or personally works for gain within the limits of jurisdiction of such other court. Now a decree is passed by Ernakulam court, for example a money decree. Defendant is permanently residing at Kasaragod. Then you may ask why the suit was filed in Ernakulam court. Because the Ernakulam court has jurisdiction, the cause of action arose here, then the suit was filed here. But the defendant is residing in Kasaragod, at Kasaragod. And you want to execute the decree by arrest and detention of that man who is residing at Kasaragod. Is it possible? 39.4 says, nothing in this section shall be deemed to authorize the court which passed the decree to execute such decree against any person or property outside the local limits of its jurisdiction. I will explain 39.4 again. It is an amendment which was brought out in 2002 CPC amendment. What is the scope of it? I will later explain. Now, if a decree is to be executed and the person against whom it is to be executed is actually or voluntarily residing within the jurisdiction or personally working for gain in another jurisdiction of another court, then the court which passed the decree has no jurisdiction to execute it, and the decree has to be executed by the court within whose jurisdiction the person resides or works for gain, for which a transfer of the decree is necessary. That is clause A. Clause B. If such person has no property within the local limits of jurisdiction of the court which passed the decree, sufficient to satisfy such decree, and has property within the local limits of jurisdiction of such other court. That means, I obtained a money decree against you at Ernakulam court. You are at Trivandrum. Your property is there. The decree is to be executed by attachment and sale of your property. Can the Ernakulam court do it? No. It can be done only by Trivandrum court, having jurisdiction. So, the property has to be dealt with by attached and sold. So, the decree has to be transferred by the Ernakulam court to Trivandrum court, where the property is situated, so that it will be dealt with by Trivandrum court. Then clause C, if the decree directs sale or delivery of immovable property situate outside the local limits of jurisdiction of the court which passed it. In that situation also, the decree has to be transferred. These are the three situations, clause A, B and C of section 39, in which a decree can be transferred. 39D, if the court which passed the decree considers for any other reason, which it shall record in writing, that the decree should be executed by such other court. That gives the power, discretionary power to the court to deal with any situation which is not fully contemplated under clause A, B or C. There may arise situations where you may not be able to comprehend all situations at all times. Therefore, it is flexible. That flexibility is clear from clause D. Then subsection 2 provides for transferring a decree. So, then 39.3, court shall be deemed to have a court of competent jurisdiction if at the time of making the application for transfer that court has jurisdiction to try the suit. Then subsection 4, which I mentioned, nothing in this section shall be deemed to authorize the court which passed the decree to execute it, such decree against any person or property outside its local limits. Now, along with section 39, you have to see order 21 rules 5 to 8 as well. Procedure is provided there. Order 21 rules 5 to 8. 5 provides the mode of transfer. How it is transferred? The court which passed the decree has to send it for execution to another court. Then the court which passed shall send the decree directly to such court, transferee court, whether or not such other court is situated in the same state. But the court to which the decree is sent for execution shall, if it has no jurisdiction to execute the decree, send it to the court having such jurisdiction. So the decree is to be sent to another, the transferee, so-called transferee court. So a decree has to be sent from Ernakulam to Kannur. The Ernakulam court has to send the decree. Then procedure, rule 6, procedure where the court decides that its own decree shall be executed by another court. That also is there. Court sending a decree for execution shall send a copy of the decree. A certificate setting for that satisfaction of the decree has not been obtained. Suppose the decree is for realization of 10 lakhs. The court which passed the decree is Ernakulam. A sum of rupees 1 lakh was realized. Thereafter the judgment debtor did not pay. He is residing elsewhere, say for example within the jurisdiction of Kannur court. So I have to get him arrested and detained in civil prison. That the Ernakulam court has no jurisdiction to do. It has to transfer to Kannur court. So I have to make the application. Mode of transfer is the Ernakulam court will issue a certificate stating that the decree is for 10 lakhs. A sum of rupees 1 lakh was realized. The balance to be realized is rupees 9 lakhs. Then a copy of the order of the execution of the decree, if no such order has been made, a certificate to that effect. Where no execution has been levied, the certificate shall contain such information. So all the necessary information which the court which is to expect the execute the decree after transfer shall be furnished as provided in Rule 6 of Order 21 by the transferor court. Then Rule 7 provides court receiving copies of the decree to file the same without proof. The transferee court will accept it, file it without any further proof. Then Rule 8, execution of decree or order by court which it is sent. Where such copies are filed, the decree order may, if the court which it is sent for district court, be executed by such court or be transferred for execution to any subordinate court. Either the district court may do it or the court may send it for execution to a subordinate court. Now, 40, 41, 42 also are relevant. 41. Result of execution proceedings to be certified. The court which a decree is sent for execution shall certify to the court which passed it the fact of such execution, or where the former court fails to execute the same, the circumstances attending such failure. The transferee court has to say, yes, this court has executed the decree in its entirety and the full decree amount is satisfied, or if it is regarding property, it has been delivered, it is fully satisfied. Or suppose it is a decree for 10 lakhs, only 5 lakhs realized, and thereafter there is no other property there which can be proceeded with, or in circumstances he can be arrested and detained, it is not possible. Then the transferee court has to say, this court has realized a sum of rupees 5 lakhs out of the decree amount of 10 lakhs and send the papers to the transferor court. It is for the transferor court to deal with the situation and do the necessary. It is for the decree holder to resort to such remedies for realization of the balance amount. It is not the worry of the transferee court. Transferee court has to obey the order which the transferor court has passed and to execute the decree to the extent possible and in the circumstances which are available and as per rules. Now, powers of the court executing transferred decree. It is contained in 42. The court executing the decree shall have the same powers in executing the decree as if it has been passed by it. Suppose it is sent to Kannur court from Ernakulam court. Kannur court will have jurisdiction to do the same thing which Ernakulam court would have done. All the powers which the transferor court, the court which passed the decree, the transferee court also has subject to such exceptions as are provided in section 42. All persons disobeying or obstructing the decree shall be punishable by such court in same manner as same manner as if it had passed the decree. That also is there, and its order in executing the decree shall be subject to same rules as to appeals, etc. So the transferee court will have the same powers. Then, without prejudice to the generality of the provisions, the following powers are there. Power to send the decree for execution to another court under section 39. So the transferee court, if it finds that the circumstances are such that the decree can be executed by another court where the parameters which are necessary for executing the decree are satisfied there, either the person against whom it is to be executed resides there or he has properties there, that transferee court also can transfer it to the another court, but it shall inform the transferor court about the same. Power to execute the decree against the legal representative of the deceased judgmentor under section 50. Judgmentor dies, proceedings are initiated against his legal representatives, a question will arise. A decree is transferred to you, transferee court. You have to execute the decree. X obtained a decree against Y. You have to execute the decree against Y alone. Y is no more. Then what is your power? It is specifically provided the transferee court has the power to execute the decree against the legal representatives as well. Power to order attachment of a decree. That is, attachment of decree comes under Order 21 Rule 53. We will deal with it elaborately. It is a very important topic. That power is also there. Then 42(3) provides a court passing an order in exercise of powers specified shall send a copy thereof to the court which passed the decree. So the court which passed the decree shall be informed as to whatever steps that have been taken by the transferring court. Nothing in this section shall be deemed to confer on the court to which a decree is sent for execution any of the following powers. A. Power of execution at the instance of a transferee of a decree. Say, decree can be transferred just like any other property. Say, I obtained a decree against you. I have to execute it in the modes provided in the CPC. See, I think of transferring the decree. Just like I can transfer my property, movable or immobile, I can transfer my decree also to a stranger. There is no harm. It is also a property. So if I transfer the decree to a stranger, that stranger can execute it, can approach the executing court with permission, it can be executed. So that power is lacking in the transferring court. That only it is retained by the transferor court. So a person cannot come forward before the transferee court and say that he is the transferee of the decree and therefore he may be permitted to execute the decree against the judgment. That is not possible. Then clause B provides that is the decrees against a firm. See the provisions regarding the partnership firm, how execution should be levied, what are the requirements, etc. are there. Other than such persons as is referred to in so and so, so and so. That means a partner whose name does not appear in the list of partners in the register of firms. That is not very important, but this is you keep in mind that the transferee court does not have the power to execute to allow a transferee of a decree to execute the decree. All other powers are there as provided in section 42. Now 43, 44, etc. 44A, you just read, that is enough. 45 also. 46, we will deal with it. Precept, we will deal with it elaborately later. Now we come back to section 39. As I said, along with section 39, you have to read Order 21, rules 5 to 8. And also, if you are in Kerala, I said in the first or second class that apart from CPC, you have to have a study, you have to read civil rules of practice as well. And so far as the High Court is concerned, High Court rules are there, High Court Act and rules are there. Every state will have civil rules of practice. So far as Kerala is concerned, civil rules of practice, Kerala. There it is rules 273 to 277. Now there are several decisions, you have to read the commentaries. We are not dealing with those decisions now at this stage, not in this episode or in any other episode. You have to read the commentaries. That such discussions will take place only in the coming episodes of the second stage where it is accessible to, or whether it can be used by lawyers and young judicial officers. That much detail is not necessary for the LLB students. So a compressed version, or a brief version is now being provided. You need not you read the commentaries and understand what it is. Just understand what it is. Now, Section 39(4) was introduced by the CPC Amendment Act Kerala 22, CPC Amendment Act 22 of 2002. I told you earlier that CPC was amended in 1999, CPC Amendment Act 1999, and thereafter CPC Amendment Act 2002, and both these amendment acts came into force on 1/7/2002, which led to a litigation called Salem Advocate Bar Association. I had also given the citation of two cases reported before the Supreme Court, Salem 1 and Salem 2. Again, I am giving the citation Salem 1 2003 1 SCC 49. Same as equivalent citation AER 2003 Supreme Court 189. Salem 2 2005 6 SCC 344. 2005 6 SCC 344. Equivalent AER citation AER 2005 Supreme Court 3353. Now 39(4) was introduced. This is only a clarificatory amendment. The objects and reasons say that this is only a clarificatory amendment. What was the law before that? Law was the same, but there was conflict of opinion among the various high courts, and therefore the Parliament thought that the controversy should be set at rest, and therefore it is necessary to have a provision. That is why 39(4) was introduced, and 39(4) makes the position clear that execution can be levied by a court which passed it only to the extent it is within the jurisdiction. If the person or property is outside the jurisdiction, it has to transfer it. That was the law even before, but as I said, there was conflict. Now it is set at rest by amendment of by introduction of insertion of subsection 4 of section 39. Now that is dealt with. I refer to Salem 1 and 2 for a purpose. That is, this provision has been considered, the validity of the provision has been considered in Salem 2 in paragraphs 22 to 24. Paragraph 22 to 24 of the SCC. I mentioned that the Salem Advocate Bar Association challenged the constitutional validity of the CPC amendments before the Supreme Court. When the writ petition came up for hearing, they sought permission to withdraw the writ petition. Supreme Court did not allow it. Supreme Court appointed a committee to be headed by a retired Supreme Court judge. Later, he was nominated, Justice Jagannath Rao. Amicus curiae was there. Then a committee consisted. The committee committee appointed by the Supreme Court consisted of two very eminent lawyers, Mr. Kapil Sibal and Mr. Arun Jaitley. Chairman, Justice Jagannath Rao was the Chief Justice in Kerala High Court for quite some time. And then that committee submitted report. Those reports were considered by the Supreme Court in Salem 2. And then Supreme Court interpreted it. And some of the provisions were held to be only directory, not mandatory. For example, filing of written statement under Order 8 Rule 1, maximum period was provided was 90 days. Supreme Court said that it is 90 days, correct? But still it is not mandatory but only directory. Section 148, extension of the period once granted. And it provided that maximum period is 1 month. Supreme Court said that there is no such rigidity. Court has still power and it is only directory. Granting of adjournments, maximum adjournments in a case 3. Supreme Court said you can have more than 3 also. Such directions were given, And so far as order section 39(4) is concerned, you please read paragraph 22 to 24. Now we will deal with the other provisions in the next episode. Thank you.